Thank you, Nick. After overcoming lawsuits and several obstacles, the Illinois assault weapons ban is facing another hurdle, a petition from a state representative.
That's right, AJ. Our Marlena Lang has more on the petition and what it means for Illinois gun owners moving forward.
Yes, Republican State Representative Dan Colkins filed the petition for the U.S. Supreme Court to review the Illinois High Court's decision on the assault weapons ban. I spoke with a local political expert about this petition, and he says it's uncommon for cases involving state law and the Constitution, like this one, to be brought before the nation's highest court.
Normally, that does not happen because the state Supreme Court has the final say on what the state Constitution means.
The petition to the U.S. Supreme Court, filed by Representative Calkins, other local leaders, and gun owners, states they filed their petition on grounds of due process, equal protection, and the Second Amendment. The petition also mentions two justices on the case who received campaign endorsements and funds from those in favor of the assault weapons ban, leading Calkins to question their impartiality and independence in the case. Kent Renfield, a former political science professor, says that much of the state court's decision was made under the Illinois Constitution, which has final say in state matters.
The decision that is being appealed addressed primarily legislative process requirements under the Illinois state Constitution.
Redfield says there are two federal issues that the petition does raise: the right to due process under the 14th Amendment and the right to bear arms under the Second Amendment. But there are concerns there too.
He is raising a federal issue, but it's a federal issue that was not addressed in the original case or in the appeal that the Illinois Supreme Court took.
While Redfield is skeptical whether or not the U.S. Supreme Court will take the case, Representative Calkins believes he and his team have made a strong case.
There are thousands of cases filed with the U.S. Supreme Court every year, and they don't take very many of them. But we're very hopeful that we've made a good case, that we have a solid case. This is a grassroots. We haven't hired some big Washington, D.C. law firm to represent us. It's the local attorneys.
Redfield also says this may be a way to get the assault weapons ban to the Supreme Court faster, as there's currently many lawsuits waiting to be heard by a number of courts, though he does believe that the law will make its way to the Supreme Court one day. Reporting in studio, I'm Marlena Lang.
Thank you, Marlena. Now, this petition does not affect the law at the moment. It will remain in effect unless the U.S. Supreme Court decides to take the case and put a restraining order on the law.
The deadline to register assault-style weapons here in the state of Illinois is at the start of next year, and failing to do so can mean criminal charges. Some raising concerns because Illinois has not sent official notices to inform gun owners more directly of the law. So far, they rely on press releases and social media. The governor's office releasing a statement about the concerns, saying, quote, "With the January 1st deadline a month and a half away, the governor is confident that gun owners will find the time to register their firearms as they are required by law to do. Those who don't, well, at some point be breaking the law and will face the legal consequences for doing so," end quote.